Great pleasure to introduce David Caruso from the University of Adelaide. And I think he's going to talk about the capacity to understand mathematical questions. So we've got to finish the talk argument until the break. Okay, great to have you here, David. And
thank you very much. Ladies and gentlemen, it's a great pleasure to be with you. And I think it followed, or I hope my presentation follows on very nicely from Norman's, because as I understood what he was saying, he was talking about the limitation of Bayes from the point of view of Bayes, and I want to talk about the limitations of Bayes from the point of view of lawyers. I'm going to address these two propositions, which effectively boil down to this: what lawyers can't do, and what I submit to you mathematicians should be doing. A brief CV, I hate these things, but it gives you a bit of background about what I do. In particular, in the last three roles that are on the slide, what I really do every day is spend 10 or more hours with politicians or administrators. And what I'm actually doing, I am living my own version of Yes Minister. And I can tell you, I can use the word with its precise meaning of a match. Because for those who are fans of Yes Minister, if you've seen the pilot episode of Open Government, if you've seen the episode of Gender Equity, they are verbatim transcripts of days that I have led. So really, spending all this time in meetings with politicians, there are very few outcomes. There's a lot of talk. And so really my aim for the presentation, and I say this with no false affection for all of you as to why I'm here, is that I think this conference has clever people in it who can produce real outcomes from what we discuss. Rather than just sharing information, we can also have outcomes. And the outcomes for which I can argue today are which courts mathematicians should be targeting and which questions mathematicians should be seeking to answer. I draw, and this is due to my own ineptitude, I don't draw a distinction between Bayes, statisticians, probabilists, if that's the right collective now, but I collectively refer to you as politicians. And I make these arguments to you, sorry, a Freudian slip.
Withdraw that.
I withdraw that. And the arguments I make are made with the goal of achieving greater prevalence of mathematical reasoning in informing the decisions of courts according to law. And in that juxtaposition there is importance, because I'm not saying we have to have one or the other. I'm talking about mathematical reasoning that actually serves and is necessitated by law. I want to draw a distinction at the outset, and that is between mathematical explanation of particular pieces of evidence to support or refute propositions, namely fingerprints, latent trace evidence, whatever it may be, DNA, and mathematical explanations for the assessment of the case as a whole. And it's on the second aspect that I wish to focus. The reason for that is really the use of mathematics to explain particular pieces of evidence boils down, particularly in Australia, to the disclosable reliability of the expertise. Once there's a sufficient reliability of the expertise involved, then generally the court will use it to interpret particular pieces of evidence. But however, whilst I focus on the second, I hope you'll see that many of the arguments I make can also have relevance to the first proposition. This is an opinion from having digested all the wonderful presentations that I've heard, and that is most of them have been focused on how mathematics can better inform trial evaluation of evidence. Trials and evidence. My first argument is that that is flawed. Is that the aim of this conference should not be directed at mathematical reasoning in trials or applied to evidence. Paul Roberts reminded me the other day of one of my great childhood stories, The Lion, the Witch and the Wardrobe. Some of you may be familiar, and that's C.S. Lewis pictured there, who I think finished his time at Cambridge. And so, drawing on Paul's Larson cartoons and so forth, I thought that in the chronicle of the conferences that Norman and others have organised, that this episode could be called For the Dogs, the Cats and the Riverbank. And I wish to clarify what I mean by trials and evidence. By trials, I mean any trial, anywhere, anyhow. Civil, criminal, accusatorial, investigatory, continental or common law. And by evidence, I mean anything that is tendered. Any single thing. Anything, document, real evidence, whatever it may be. I'm not suggesting for a moment that I'm dismissive of the presentations that I've seen. They of course have utility. But what I understand our purpose to be is to promote mathematical reasoning in courts, not necessarily trials. So in terms of language, I draw that distinction in the subject matter of the conference topic. Why not the trial court? I would submit to you that trials are the worst place to establish a mathematical front. And I'll go through some reasons. Volume. Trials resolve, roughly in common law jurisdictions, 1.5 to 2% of disputes. A significant portion of those disputes are in what we collectively call small claims jurisdictions, where increasingly, forget experts, lawyers are not permitted to appear. And because lawyers are not permitted to appear in those jurisdictions, at least in Australia, there can be no orders for costs. In other words, there is no financial imperative to finish. So the thing which drives resolution in the small claims courts is lunch rather than logic. Now, as an aside, I got a couple of laughs there because we all understand what a sandwich is and how and why you eat it at lunch. So to draw again on my friend Paul's analogy of how do we understand what the lion is saying? I try and pick terms that will be appreciable by a diverse audience, as I do if I'm addressing a jury or indeed a constituency of judges, because it's an exercise from the outset in disparate advocacy rather than differential advocacy, trying to select one person over another. Second reason, money. Patricia, I think, made the point very validly in discussion yesterday about effectively that we're after the cheapest report we can find. Now, there's nothing remarkable about that. Unless nepotism or corruption guide the use of public money, it is always the least expensive tender which wins. And you all know that from the fact that many NASA astronauts have said they are going to the moon in the cheapest spaceship possible. South Australia, to give you a perspective from my home jurisdiction, $10 million has been cut from the legal aid budget over the next 4 years, beginning last financial year. That's $4 million from the state input and $6 million from the Commonwealth input. You may think, well, over 4 years that's unremarkable, but the Australian spending on legal aid is 6 cents per person per day. So we are not eating into a chest of riches. It's also important to remember that in legal aid, in particular, there are milestone pay scales. I'm not sure if they're the same in England, but effectively, legal practitioners get paid for certain attendances at court, namely a first appearance, a plea. So there is an unfortunate sparring that occurs between the ethical duties of the practitioner to properly represent their client and the mere fact of business realities of their caseload and how they actually deal with the evidence before them and to what extent they can dig. For that reason, there is a limit to the number of cases in which there will be a defence budget in particular for expert evidence. Now, that means that where it is given, the defence lawyers are often looking for basic conclusory statements. The more time spent learning and understanding with the expert, the more cost involved, and the more that can potentially be uncovered in a trial. Not for every case, but for the vast majority of cases, we are looking for that cost effectiveness of the expertise that's been engaged. I draw an analogy with civil law.
Could I try to clarify, please? Are you basically saying that if an expert opinion is necessary for a defence, it might not get funded and therefore not be used?
Absolutely.
Yes,
Okay.
absolutely.
Absolutely.
Same here. Brilliant.
Absolutely.
Yeah.
Just because the lawyer who is briefed by legal aid, which is effectively run out of a commission, which is an arm of government, effectively, says we need expert evidence or we'd like expert evidence, does not necessarily mean they'll be funded for expert evidence.
That is built in justice.
Yeah.
Yes,
That's the budget that is the budget given by governments to effectively legal aid, which is the majority of defence law. The marketplace, however, means that much the same is for the commercial and civil arena. I do a lot of work in effectively information technology fraud and theft. Now, in order to detect that, we often have to issue civil search warrants and retrieve computers and have them scanned. Now, that starts you with a $50,000 bill, and that's before you know you have a case. So there is a cost associated. Defence lawyers. Now, I am trying to be relatively provocative, but defence lawyers are a fairly conservative bunch. And I don't mean any offence by that, David Bentley, and I think it's true of all lawyers, really. I'm going to come back to conservatism. Certainly in my home jurisdiction, they're quite conservative. They're affected by the money issue, which I just discussed. They have no money, no time, and therefore a limited ability, despite their best intentions, to actually engage with expertise. Large numbers, likelihood ratios that have several zeros after them, clever people, such as all of you in the room, who without sufficient budgets for the defence lawyer to properly inform themselves, well, the defence lawyer says, best leave it out. Let's leave it out. One less change.
Disagree.
I am being provocative.
Hopeless idealists. We're all hopeless idealists.
Absolutely.
That's why we're not commercial lawyers. That's why we do legal aid.
I'm looking forward to the sparring later on.
Sorry.
No, not at all. Prosecutors. Now, I'd like to be particularly provocative with prosecutors. They seemingly start with nothing, and the burden is on them, but I would suggest to you that the hurdles are not so high, and this may be where David and I do agree. The jury's told either by the judge or the prosecutors themselves the presumption of innocence. Empty your mind. Come with no preconceptions. Beyond reasonable doubt, listen to the Crown. The onus is on the Crown. The burden is on the Crown. The Crown must do everything. So the prosecutor really begins with empty vessels that give him or her their full attention. Therefore, broad statements such as, ladies and gentlemen, we will prove, we will show, we will establish, uses words that people directly understand. Oh yes, I know what prove means and establish. Whereas if I start, or at least come around to something that looks like this, then the person in the jury box, and indeed the judge, starts thinking about other things and not paying attention. And you lose the vacuous mind that you've been given. Judges. Now, in Australia, there are no such thing as civil juries, and there is a right in state criminal cases, which are the majority, to have a trial by judge alone rather than a jury, and the defendant can choose. Now, even if an arithmetically erudite judge tries to use some form of mathematical reasoning to piece it all together, it's very likely, as we've seen from all the cases that have been put before us, that brother and sister judges may feel a certain discomfort with that. There are also the attendant conflicts that other speakers have addressed regarding the ability to apply values to presumptions of innocence beyond reasonable doubt standards through priors. Jurors. Jurors are the main reason I submit to you to rethink the trial focus. Jurors are inscrutable. From what I understood from Christy and Bill, and I hope I'm not misquoting you, but you'll correct me after if I am, the studies you've done assess the influence levels or expectation congruence with mathematical reasoning rather than direct comprehension or ability to apply a mathematical formula. even in the case of jurors telling us they have made basic arithmetical errors that have resulted in a misapplication of law to persons on criminal trial, their deliberations are incubated. I'm going to run out of time horrendously, I'm afraid. This case was delivered on from our highest court in Australia on Wednesday. The 4 chaps there, the first one, NH, is suppressed because he's a youth, were charged with murder. The jury were directed in terms of each of the 4 possible verdicts. Murder under the law, the Jurors Act, has to be unanimous. The other 3 verdicts can be by a majority of 10, 12 being on the jury, after 4 hours. The foreperson came in, they deliberated, it was after 4 hours. He answered the associate to the judge's questions, and the verdict for each of the accused was not guilty of murder, but guilty of manslaughter. Jury thanked, they depart. Later that day, the foreperson phones the court registry. I made a mistake. I mistakenly told the court that at least 10 of us had agreed on the verdict of not guilty of murder, which was required before you could go to manslaughter. The case is called back on by a different judge of the Supreme Court. Affidavits ordered from the foreperson and the other members of the jury, they all support the mistake. It doesn't seem clear that there was indeed a 10 or more majority. The DPP, Director of Public Prosecutions, appealed to our Supreme Court, seeking the verdicts be set aside and new trials ordered. A majority, 2 against 1, of our Supreme Court, which is an intermediate appellate court in Australia, agreed for the reasons here. Effectively, because the jurors' verdicts were not delivered in accordance with law, they could not be seen to be proper verdicts, and therefore the court had inherent power to overturn them. Inherent in law is a bit like I think Jeff said with guidelines. It's a word we use when we don't quite know what we mean, but we think the power should be there. Each accused all sought special leave, which is a special application to appeal to our highest court. It was granted. It is fundamental to understand that the case before the court involved 4 appeals whereby the effect of the lower court's decision, the Supreme Court's, was to overturn acquittals for murder. And therefore, 7 of our highest court judges all agreed. You can't do that. Now, what that case should really raise is that jurors, in my opinion, are a bit like the babies in the literal and figurative sense of criminal justice. They don't say anything, they don't ask any questions, sometimes they smile, sometimes they cry and want to go home, but in the end we're not really sure if they can count to 10. And the scary thing, or the thing that I invite you to take away, is not that this is a one-off case, that this is the oddity whereby the jury made the mistake, that this may be actually the only jury that recognised that they'd made the mistake, and we don't know. Conservatism. Why can't we understand the lion eating the sandwich? Well, look, my assumption is that scientists and mathematicians generally like to break new ground. We don't like that in law. We don't like new things. We like questions to which we know the answer. We don't like surprises. In fact, the points that were made about the importance of jurisdiction should highlight that for you. That in Australia, for example, most areas of law, civil and criminal, there are 8 jurisdictions in Australia, and each one has a different criminal law. So the lawyers cannot really even agree on a set of laws to all follow, let alone invite reasoning processes from outside their nest. In sum, I would say let's forget mathematical reasoning in trials. Now, I have run out of time horrendously, but I can try and if I can eat into lunch a little bit, perhaps. Yeah. Oh, it's nowhere near done. Capacity building of lawyers. Yeah. Look, realism, the cat and dog experience. In summary, I don't think that anyone can be an interdisciplinarian. I don't think that's a proper way to have a professional practice model. It's possible for some, but it's certainly not sustainable to be at the top of the field in 2 areas. So I think what we have to accept is that we're looking for multidisciplinarians, people who appreciate to generate a greater sense of appreciation, particularly in lawyers, the awareness skills of our mathematical counterparts. And there's a need for us to do that. This case was delivered last month. Experts were called to give the likelihood about different causes of industrial fire. It's a New South Wales case. And both people were criticised by the court. The experts for not properly outlining their assumptions and their connection to their opinions, and the lawyers for not properly doing their job in actually assisting the experts to give their expertise and connect it with the facts. Capacity building. There was a piece by Frank Carrigan, who's at the Macquarie University, now Australian Financial Review, where he made these rather offensive to many remarks about legal education. Effectively, that it completely narrows the mind and stifles the ability to be curious. Now, Carolyn Evans, who's the Dean of Melbourne University, and I have both sort of hit back at Carrigan. But given that I'm feeling wistful, does he have a point? To what extent does a law degree actually require alternative discipline study? And if I can. This is a paper that the committee I chair at the national level put out last year for national consultation, and it really goes through a worldwide review of law degrees. You'll see, if that's big enough, it probably isn't for the back, that indicates the core syllabus of a law degree across different nations. What's noteworthy is that evidence, really, in the core curriculum is the only real topic in a curriculum that ostensibly lends itself to the study of other disciplines, because that's where we're trying to look to prove things. In England, evidence, procedure, ethics, and corporate law are not compulsory modules of study.
Shame.
And that really does stifle the ability to have to deal with these things.
Well, some of them are if you're a practitioner.
Exactly. And look, my response to that would be, that to engage with reasoning whereby you're going to resolve a case, it's not sufficient to go to continuing professional developments on a 1 hourly, 2 hourly ad hoc basis throughout another professional career. Our Chief Justice is called Robert French, which is apt to confuse in Australia, but he often says we really have to, as judges, put ourselves in the position of someone with a doctorate. Now, that was first raised in 1933. On the way over from Australia, there was an announcement that could we have a doctor? There's someone that needs medical attention on the plane. I thought about putting myself in the position of a doctor and giving medical attention. Then I thought of the irony of when that medical attention failed, the judge would put himself in the position of a doctor and say why I had not given proper medical treatment. So I await the call that will properly show the gravitas of mathematicians and lawyers on planes by seeking our expertise at short notice. It's futile to look at real capacity building for lawyers, largely because even if we do it, we've got such a low strike rate. In Australia, there are 66,000 practicing private lawyers. There are 36,000 law students in our 41 law schools. The job market is at 12%. Namely, for each graduating cohort across each jurisdiction, there's a 12% job availability market.
Wow.
So even if we train them, it's very unlikely that the people we train will get to the positions we need them to be. At our secondary level, I'm on the SACE board, that's the equivalent of GSCE here. Our lawyers can have never done a calculation without a calculator since they were 15. In sum, I think capacity building is problematic. If I can seek your indulgence, thank you. Is there hope? Jeff asked, is there hope? I think everyone's been looking for hope. I think there is hope. A new hope. Mathematicians, I suggest to you, need to change the questions they're seeking to ask. The questions here have arisen from answering particular pieces of evidence. That relies on the evidence first being recognised, produced, presented by a lawyer. who's less able to recognise that it needs that interpretation than any of you. So you'll suffer the same problems above. I suggest that a change in tack should be to look at questions at their source, in legislation, especially where the law on the books increasingly invites and even demands mathematical analysis. Very quickly, over the weekend just past, the Northern Territory, which is the red bit, had an election. And a Justice Alliance made up of social and legal institutions had 6 asks. Ask 3 from the new government. Ask 3 was that there be increased community-based sentencing. In other words, instead of sending people to prison, find options so that they can remain in the community. They relied on a study that showed people sent to jail compared to people that were based in the community, particularly our Indigenous youths, were 5% compared to 18% more likely to not repeat offend. The opposition, which committed to that, was resoundingly elected. You may think, well, that's just one correlation with no basis that I've plucked out, but this is a photo from the Dondale Youth Detention Centre in the Northern Territory. And it was aired on a Four Corners program, which is our primary investigatory news media in Australia, that showed horrendous treatment of particularly youth detainees. A Royal Commission of Inquiry has been established. That reflects an Australian sentiment towards smarter and better approaches to sentencing. In South Australia, there has just been released draft legislation that completely rewrites the sentencing law of that state. And the new laws focus on increased community-based sentencing. The law derives, it is based on statistical studies that evidence reduced recidivism with community-based sentencing options. It's grounded in statistics. The chess set really begins from the point of view of the mathematician. This is not the lawyers making the rules, we're trying to write the rules around the statistics. This is the sentencing options. You can put the sentencing judge, and put them, if you see, I've gone in least significant offence to most. But the legislation you'll see works backward, always starts with the most grave form of punishment. They can be released into the community, subject to orders. They can be suspended, GRS means good reason suspension, and put on a bond. That's without any penalty. They can have a good reason suspension with the imposition of a custodial sentence if they breach. They can be suspended and put on an intensive correction order, which is a more invasive form of community correction. And for certain types of offence, they can be sentenced and released into home detention, or they can be put in prison, but that's very out of fashion nowadays. How are the sentencing judges, when this becomes law, meant to do that? How are they to choose the category of sentence? How are they to choose from the vast array of conditions that they can attach? How are they to assess, to self-assess, if the sentence is the proper one, the category correct? Most importantly, how are they to assess the respective success of each category in achieving the aim of the legislation to reduce recidivism, so as to determine the effectiveness of sentencing by courts and the effect of the law reform by government? I would suggest statistical data could be used on every single category. There are some lovely excerpts which I just highlight. Section 62A, the middle, suggests that in home detention, the court has to look at the premises as being properly maintained and cared. There must be some form of statistical data that informs that decision, unless it's to be criticised as a value judgment. 68.2, which informs an intensive correction order, is riddled with possibilities for statistical analysis as to whether there is indeed a moderate to high risk, whether there is a likely or limited chance. I would say sentencing courts are the place to establish the mathematical front. The language of the legislation invites maths. Certain provisions necessitate it. Legislative sentencing reform is grounded in statistics and therefore should be measured by statistics. Statistics means that we can move away from the idea that sentencing is inductive synthesis, whereby all the information is put into the sentencing judge's lap, and through a synthesis they induce a penalty, which provides for public distrust. Legal prescriptions of the type Norman and others have mentioned are diminished. We can use the antecedent history. We can use all those measures around a particular person which are taboo in the trial. We can have priors without the problems of legal prescriptions against them. There's transparency in the reasoning of courts. It's publicly available. It puts the mathematicians and the lawyers in league with a mutual interest in demonstrating how the reasoning shows correctness of sentence. In conclusion, I would say the focus on the trial and the evidence is important, but a change, or at least perhaps an expansion, should be to sentencing courts and questions that arise from legislation. In other words, questions that arise and are demanded by laws themselves rather than by a piece of evidence. I should say the sentencing bill, I was trying to print copies because I'm a lawyer and I like working from paper. But if anyone would like to see it, it is released from consultation. I would be very pleased to provide a copy and indeed have your feedback. Thank you very much for your attention.
Well, we're almost on the lunch break. If someone's got a relatively quick question, short question, or is everyone wanting that sandwich? That looks so tasty. You want to get one of those? Thank you very much.
Thank you.